Hello and welcome to Insolvency and Restructuring in a Pandemic, brought to you by P.R.I.M.E Finance. My name is Camilla Macpherson and I'm Head of Secretariat. I'm going to start today's session with some housekeeping. This session is being recorded and will be distributed later. Attendees are muted and have their video turned off. If you have a question or comment, we'd love to hear from you. Please use the Q&A function to get in touch. It can be helpful if you include your name and affiliation. We will use a chat box to send messages to all attendees during the course of this session. Thank you to Dwar Financial Technologies, FTI Consulting, Morrison & Forster LLP, and Rutter Associates for their sponsorship of the second series of Prime Time. Thank you also to Lexis and MLEX for assistance with promotion. I will now hand over to Judge Elizabeth Stong, Judge of the United States Bankruptcy Court, Eastern District of New York, who will introduce the panel and moderate the session. Thank you.
All right, thank you so much. Thank you, Camilla. Thank you, P.R.I.M.E Finance. Thank you to our fabulous speakers. And thank you, of course, to our attendees, both our speakers and our attendees. And as you will soon learn, our topic spanned the globe. And that was our goal. We want to present in this hour a perspective, a range of perspectives on insolvency and restructuring in a pandemic, the global view from the boardroom and the courtroom. As you heard, my name is Elizabeth Stong. It is my great pleasure to be your moderator and guide as we circle the world with the assistance of three, superb, it's hard to come up with a big enough descriptor, speakers to take us on this tour. The first, just taking the introductions in alphabetical order, is the Honorable Heath QC, a retired judge of the High Court of New Zealand, currently practicing as a commercial arbitrator and mediator at Bankside Chambers, also a justice of the High Court of an island nation that you may know as Kiribati, and we've learned it's pronounced Kiribati. Paul is legendary in his work at Uncitral and elsewhere in international insolvency, and we are thrilled that he has gotten up very early in the morning indeed. It is tomorrow from a New York perspective or a UK perspective, already in New Zealand, and so we are delighted that Paul is with us. Thank you, Paul. We're also halfway around the world and in the other hemisphere in both directions. I'm so fortunate to be joined by Mr. Justice Nick Segal, the judge of the Grand Court of the Cayman Islands and barrister based at Erskine Chambers in London, previously a partner at Freshfields. Nick, again, really needs no introduction, and I should be appropriate and say Mr. Justice Heath and Mr. Justice Segal, but we've agreed we'll go back and forth on that today. And he as well will share his perspective, not only as a judge who hears very interesting matters that touch typically on multiple jurisdictions in his role in the Cayman Islands Grand Court, but also in his practice as a barrister, and really one of the preeminent barristers in this field in the UK, the continent, and really the world. And then finally, third alphabetically, but the first of our speakers, we are so pleased to be joined by James H.M. Sprayregen, I think known universally as Jamie, one of those people who you say the first name and people know who you're talking about. Mr. Sprayregen is the head of the insolvency restructuring practice at Kirkland Ellis, and is very humbly just said partner Kirkland Ellis LLP for his background. As with our other panelists, while he may not be an honorable, he is a legend, and we are again very lucky to have him with us. So to start us off on our world tour, I'd like to begin with asking Jamie to give us a bit of the US perspective, cases and trends, what you see happening in both cases that are being filed and may be filed, and how everybody is navigating. I'll say this is of special interest to me as a judge, the virtual environment. Please, Jamie, take it away. And thank you.
Thank you for that kind introduction, Judge, and honored to serve on this panel with the other esteemed panelists. So I was asked to maybe give a little perspective on what's going on in the United States, and I'm sure it mirrors what's going on around the world, but everybody's got a little bit different experiences. You know, I kind of date the start of the pandemic in the United States from the night the NBA basketball teams shut down, which was Thursday night, March 12th. And that's when it really, I think, really came to everybody believing that the world was changing in the United States. Up until that time, we'd sort of been bumping along. And at that point, it was, people have asked me over time, what kind of recession or restructuring boom have we gone into? Is it like the great financial crisis, or is it like 9/11, or is it like the time of the Asian financial crisis in the late 90s? And I pretty much say I think it's more like a 9/11 to the X power, and kind of pick your power. And what I mean by that, at March 12 and on, and a little bit before March 12 for others, was really an incredible shock to the system. And the economy did not shut down in the GFC the way it shut down in the middle of March in the United States. If you look at many of the companies that got into trouble, it's not in anybody's business plan to operate in a zero revenue environment. That just wasn't anything anybody planned for. There's a whole bunch of winners in this pandemic, of companies that happen to be doing things that people needed more of, or needed to access, or could continue to access. And we're not going to talk about those today. But the ones that had this incredible shock to the system, it didn't go away, and it hasn't gone away. Like 9/11 didn't go away quickly, but it went away a lot more quickly than we're now. We just passed our 7th month of going through this. And so early on, massive shock to the system. First few weeks, it actually caused a wave of bankruptcies in the United States. I kind of called that stage 1, because that was more companies that were pretty much destined to go into bankruptcy or Chapter 11 or some kind of restructuring in any event. And the shutdown and the pandemic pretty much accelerated that. In the main, that was retail businesses and a decent amount in the energy area. Energy's its own kind of bespoke. It was tremendously impacted by the pandemic, but it was going through its own round of restructuring even before that. But it was exacerbated and accelerated by what happened in mid-March. And so you had a whole bunch of, early on, we were working, literally 20-hour days, just with incredible amount of either input of new stuff or stuff that had been in the system, but just kind of blew up on us. As you got to the end of March and into early April, there was actually a massive amount of instability in our system. And our Congress and our Fed and our Treasury all acted. And unusual, maybe I can be the one to say this as an American, but unusual, we acted actually pretty functionally out of DC and with great alacrity. And had not, I always talk about what's the sound of the dog not barking. What didn't happen? Well, what didn't happen is a massive shutdown in the system, because when you throw $2.5 trillion at a problem, it can make a difference. And it did make a difference. We had a whole bunch of companies, highly leveraged companies, especially in financial services and some in structured finance areas, that would have been in bankruptcy and may have been ugly liquidations had all of that liquidity not been injected into the system in late March or early April. And so that actually helped us move into what I'll call stage 2. And that massive injection of liquidity took a lot of the volatility out of the system. And if you track distressed trading ratios, that is bonds trading at more than 1,000 points, and if you look at the default rate predictors and all of that, there was a massive drop from April into May and June. A whole bunch of companies still got in trouble and ended up filing, who were on their way anyway, or because of the zero revenue environment, particularly travel, leisure, et cetera, were sort of tumbled in to filings. So that continued to go on through the summer. But I would say, interestingly, now where we are coming out of summer and into fall, and I'd say maybe we're in stage 3, filings have actually gone down materially Distress trading bonds, if you look at, again, the ratios, they're down materially. Default rate predictions are down materially. We'll see if they're right. But I think for the rest of the year, barring, again, some exogenous shock, that things are calmed down. There's massive inventory in the system, lots of new bankruptcies. But I don't think you're going to see a ton of new filings between now and the end of the year, and even maybe going into the first quarter. Now, having said that, it's not a free lunch, because the injection of liquidity into the system, the way I put it is, I think a lot of companies accessed runway, accessed liquidity at the expense of solvency, or at the expense of ultimate solvency. Because what happens is your leverage goes way up, your earnings capacity, your revenue is down, your leverage ratio means it goes way up, and your ability to handle the debt and work it down and work it off is not what it was. And for some number of companies in the United States, somewhere in 21, I think, could go into 22, you're going to see restructurings, workouts. I don't mean ugly liquidations. I mean basically change of control transactions where the equity probably will be cut out, and lower levels of the junior debt structure may be cut out. There'll be a change of control. These might be prearranged or prepackaged. They might not be. But it actually, I think, ultimately will be healthy for the system to have somewhat of a, what I call going through the car wash, to be able to wash some of the debt out of the system, because I think there is too much debt in the system for a lot of these companies to handle. Not all of them by any means. And again, this presumes a vaccine and that we're, things don't get incredibly worse. So we'll see. And then, I would call that could be, round 4. And round 5, I think, is even further out, is what happens to real estate, because not much has happened yet. Everybody's speculating that with everybody out of their offices, everybody needs less real estate. And even if the need is only 10 or 20% less, that would have a profound impact. But the way, leases work, real estate moves slowly. I know our own firm, our first lease isn't up till 2024. I think whatever happens in real estate will be a little further out and is not a 2020 or 2021 issue. And then I'll leave it at, and move on to the other panelists with maybe a big compliment to the system. Obviously, the government riding to the rescue with a lot of money, I think, made a big difference. But the court system really stepped up. Obviously, we're all on Zoom now. We've had Zoom hearings and other technological things around the country, and it worked. And I actually think the bankruptcy court system handled it better and quicker, more than anybody else, any other court system. And I've talked to a lot of my litigators, state courts or district courts or appellate courts, probably because they had to, because the cases were rolling in immediately. There was no break. And everybody kind of muddled through and figured out how to handle the new normal. And judges really around the country, everybody had a little bit different way of doing it, but everybody handled it. And we did not just hearings, but trials with witnesses, and it worked. And I was actually getting calls from people in Congress and other people who wanted to help, saying, is our system, do we have the capacity in it to handle what's coming and what's come so far? And I actually said, I think we have lots of capacity. And from various conversations I've had with judges, is that so far so good. We'll see, because, knock on wood, but I think there could be a lot more to come. But I think the system has proved to be very resilient, and wasn't built for this, but we figured out a way to, as I said, kind of muddle through. And that part is, a really compliment to the court system. And I would say all the practitioners also. We all had to figure out how to try to settle things and negotiate and in a different way, but we've done that. And I think whenever we get back to normal, I'll put that in quotes, because there will be changes in how we do things. And maybe we'll move on to that at a different time, but things will never go back to exactly the way they were, but they're not going to stay this way either, I hope.
Well, that's for sure. There's a saying, and I don't know where it comes from, that you never step in the same creek twice, because of course you change it by stepping in it. And I thank you for your kind words about the system and the judges and my colleagues. I'll turn it around and say that the responsiveness of the bankruptcy bar here, as always, Of course, my window on it is domestic, but I suspect this is true internationally. Perhaps we'll hear from Nick and Paul as well, has been just extraordinary in terms of taking a problem and becoming a problem solver. I'm intrigued by your stages as you map them out, because one thing I've seen in some cases has been kind of a stage 0, which is cases that were on file already that might have had a good shot. And then then there's more to deal with than ever anyone could reasonably have anticipated. Have you seen any of that, or is that just too small a segment of the caseload to make a difference?
No, I should have mentioned that. That's a very good point. I mean, the cases that were in existence kind of went into almost like what I'll call freeze frame. Some of them, if you had an existing retailer in a bankruptcy case, you know, the traditional way of putting them out of business was to do going out of business sales. Well, you can't do going out of business sales when the store is closed and there's no customers and the mall is closed by state order. So we all had to figure out ways to deal with that. And there were definitely companies that may have survived that didn't survive as a result of terrible timing of filing just before. I would say that, you know, we gave a compliment to the system and the professionals. I would say the banks, probably not because they're such nice guys, but because it was in their own self-interest, were pretty cooperative early on. They're still cooperative now, but I mean cooperative in forbearance and things that they might have been well covered. And so if ordinarily they might have pushed more for a liquidation as a way to get their recoveries. Well, that wasn't going to happen here. So you ended up with more cooperation and buying time with some of the existing cases, even though they weren't going to make it. Some were, and the ones that weren't. But we found ways for the ones that weren't, to give them what I'll call a decent burial as opposed to a really ugly one. So that was maybe stage 0. That's a good way to put it.
You know, it's an interesting point, and something I've seen or heard, since it's all telephonic, in some of my cases, including in some consumer cases, the idea that lenders now appreciate, one lender's lawyer put it in these words for a large national bank, that it's time to be kinder and gentler. And whether it's coming from a sort of, you know, a bigger picture sense that this is the time to be decent and take a long view, or a very shrewd assessment of the fact that the alternatives are not attractive. You know, if you still wind up at the same place, I guess there's nothing wrong with putting a happy wrapper on it, or at least a very positive kind of wrapper. So we shall see. Is anyone going to work in the office in your firm, Jamie?
We're not officially open, but I would say we keep stats based on use of key cards, and people can come in voluntarily, and 10 to 20% of the lawyers are coming in voluntarily, not every day, but on any given week now. That's domestic. You know, Beijing, Shanghai, and Hong Kong, we're pretty much back to normal, and same in Germany too. But domestically, we're still limping along out of the office. But I would say, as a law firm, again, just like the bankruptcy system, you know, we got at it, and it's worked out fine. And so we're not in a big hurry to put anybody in harm's way, because it's working fine. And hopefully by the time everybody's coming back, there'll be a vaccine.
So you made some points about things that are working well in court proceedings. And of course, the US bankruptcy system was already electronic and had been for years. I wonder, is there a takeaway that you've learned from, you know, running big cases, big teams, working remotely, that might have been an insight, or is an insight you would not have had without a need into this different kind of work environment?
Well, I think in the what I'll call the opportunity set for folks who are on the older end of things, unfortunately I put myself in that category these days, who already had an established network, brand, reputation, et cetera, this was a lot easier. I think for new practitioners and people just coming out of school, this is very tough. And it's, you know, the network, we were talking before this panel started, actually, where we all met each other, and it was at different places around the world, and serendipitous developments, and you keep up with people, and how you develop your network and relationships over the years is pretty is mostly through personal contact, and the lack of that availability for young people, I really feel for them, and I hope it doesn't last that long, because I do think that's the lack of serendipity, both inside your own institution and being able to get around and talk and meet with people, that will hold you in good stead for the next 5, 10, 20, 30 years, that you have no idea how that might be, is what I think is the real, crime of the situation for young folks.
It's such an important point, and it's good to hear from people in this setting, in a Zoom setting, but I think it's different than being in the room. And I think as a practice area, as a profession, it's something we need to be mindful of. So thank you. Let's cross the pond, if you will. Let's hear from Nick Segal, who's going to share some perspectives on practical issues that arise in the courtroom, virtual meetings and a scheme of arrangement, how that's working, maybe a couple of examples of particular cases, including, I'll say names, Virgin, Pizza Express, and of course the UK's new insolvency restructuring law. Nick, over to you. Excuse me, Mr. Justice Segal. So much fun to say that. Thank you.
Thank you very much indeed, Judge. Excuse me. Well, in the very limited amount of time that I've got available, I want to touch on, and I mean just touch on, 4 particular topics. First of all, how courts have dealt with the increased caseload and delays resulting from virus-related issues. Secondly, I want to look at some practice points that arise in dealing with hearings which are not in person, whether they're a telephone hearing, whether it's a hearing by video link, or indeed whether it's a disposition of a case without any hearing at all, because it's disposed of just on the papers. Thirdly, I just want to highlight what I think is an important question, namely, what are the limits of the technology? In what circumstances is it inappropriate to hold a remote hearing? And then finally, and very briefly, just to mention the way in which the courts have accommodated the need for remote hearings in schemes of arrangement. Now, this is primarily a judge's perspective, a litigator or a courtroom perspective. I won't have time, obviously, to refer to the many practice directions and guidance notes on the issue, nor indeed to many of the cases that underlie what I'm saying. But I hope you'll understand that in the limited time available, I can't really do that. So let me just move on to the first topic, which is caseloads and delays. The pandemic, as everybody knows, has seen a rapid and substantial rise in corporate bankruptcies, and with it an increase in cases to be dealt with by the courts. In London, for example, there have been a huge number of restructurings being done by schemes of arrangement, each of which involves 2 court hearings, one at the beginning and one at the end, and so judges have been kept very busy. One London Silk said to me recently that she'd done more schemes of arrangement in the last 2 months than she'd done in the previous 25 years of practice. So you can get a sense of the number of cases that are being dealt with by schemes and the demands placed on courts as well as practitioners. And that increased caseload has required revisions to listing procedures so that the most important applications can be identified and heard as rapidly as possible, and that the routine applications are adjourned or, if appropriate, dealt with on the papers. As regards applications by parties for more time, I think the courts generally have accepted that there's a strong public interest in the continuation of the administration of justice, and that justice delayed is justice denied. So courts have taken the view that as many hearings as possible should continue. They should do so remotely, so long as that can be done fairly and safely. and that the objective has to be to keep to existing deadlines, but where for whatever reason that isn't realistically possible, to permit minimum extensions of time which are reasonably practicable. And extensions of time which require the loss of a trial date are obviously going to be granted much less readily. In my own court, I've had a whole series of these kinds of applications, mainly for extensions of time for the production of discovery and for the service of evidence because of the difficulties in getting hold of documents, in getting hold of people. But I've not had an application so far to vacate a trial date, which I must say seems to me to be indicative of the fact that, as Jamie was saying, applies in the US. In Cayman, the legal community, ably supported, I have to say, by counsel in London, have done a great job in adapting and keeping litigation on track. Now, a few practice points regarding remote hearings. And I think it's worth pointing out at the outset that the position in Cayman is a little different from a number of other jurisdictions, because for many years we've had full-time but non-resident judges like myself. I took over from Sir Peter Creswell, who had retired as a High Court judge in London, but then sat in my court in Cayman. So we've had a need to put in place rules to accommodate judges who have to deal with judicial business when they're not on the island. So even before the pandemic, our rules dealt with cases in which the judge would be off island, would participate remotely, and in cases in which counsel and witnesses needed to do so as well. So I think we had got used to, and I like to think have been innovative in our use of the technology required for remote hearings. But of course, as Jamie said, as you've said, Judge Stong, the remote hearings have become absolutely the norm for all types of application. In Cayman, prior to the pandemic, it was generally only possible to have remote hearings for interlocutory matters. But now remote hearings for trials are permissible and used frequently. I've conducted a large number of interlocutory hearings, which have spanned in duration from 1 hour to 4 days. And I've had a number of trials, 2 of which were 7 days in duration, and I've got another trial of 8 days coming up next month. I also deal with a significant number, and I think there's been an increased use of applications on the papers. Those applications have always been appropriate for uncontested insolvency and company matters, but now get used where there are contested matters of limited scope, which don't require fact-finding by the court. Prior to the pandemic, certainly in my court, we would generally only deal with a matter on the papers with the consent of all parties. But now we will direct inappropriate cases that the matter be dealt with on the papers where we think that's appropriate. There is, I must confess, something of a bad habit that has developed with these on the papers hearings, at least in Cayman. Some counsel are inclined, I find, to think that they're entitled to a judgment by return, that the court is providing a judgment on demand service. But I have to say that, at least as it relates to me, counsel are fairly rapidly disabused of that particular notion. But there is the idea that this is all rather nice and convenient now. You just file the evidence with a few papers and let the judge sort it out. Well, that I don't think is an appropriate practice. We don't use telephone hearings very much in Cayman. I know they're used and favoured very frequently by the bankruptcy courts in the US, but in my experience, they tend to require a very structured participation to avoid disruption. And I know in London and in my court, the relevant practice directions and user guides indicate that hearings of less than an hour or 2 hours are the ones which are only appropriate for telephone hearings. As regards video hearings, it's obviously been necessary to update and expand the applicable protocols and procedures to ensure that the necessary steps are taken both before and during the hearing to allow the hearing to be conducted smoothly and fairly. And I do emphasize both before and during, because PrEP does become very important. Let me mention just a few highlights. Sitting hours, I think anyone who's been involved in a number of video hearings will acknowledge that they tend to be more draining and a little bit more demanding in terms of focus for those involved, and sometimes even a bit slower. And in Cayman, we have a practice direction which stipulates that a full day hearing will generally not last for more than 4 hours, although my own practice is to sit longer when that is necessary and properly justified. Secondly, and rather obviously, the efficient use of electronic bundles and real-time electronic transcripts is absolutely crucial. Thirdly, witnesses, a good deal of effort, at least as far as I'm concerned, needs to go into getting this aspect right. Consideration needs to be given to the arrangements for witnesses at the relevant remote site. Ideally, these should follow as closely as possible the practice adopted when a witness is in the courtroom. So, for example, during examination and cross-examination, the witness has to be able to see the legal representative asking the question and anyone else making any statements with respect to the witness's evidence. And witnesses during their examination in chief are usually asked to confirm under oath that they're alone in the room and that they're not receiving any assistance from any third parties during the course of the hearing. And it may well be sensible, I've certainly insisted on it myself on occasion, that there's more than one camera in the location from which the testimony is being provided to ensure that impermissible reference to notes and prompting isn't taking place. And sometimes witnesses may need to give their testimony from a solicitor's office or counsel's chambers, and then suitable arrangements need to be made in relation to that. Fourthly, remote hearings, I think, present a particular problem for open justice, which may not be a huge issue for some bankruptcy cases, but is often a big issue in bankruptcy and related cases. So consideration has to be given as to how the public can be given access to the proceedings. And this has been achieved in a number of ways. We've done this in Cayman by making a facility available in a particular courtroom so that you can have a live streaming of the hearing to a location where members of the public, subject of course to suitable social distancing, can view the hearing, or you have a recording by video or audio link which can be viewed subsequently in a designated court building, or you can allow the press to join the hearing remotely, perhaps with a suitable password access. And in our court, the court can direct that a transcript of the hearing be made available to the public at no expense. Of course, where parties or the press are allowed to observe a hearing remotely, they need to be reminded that it will be a contempt of court to make an unauthorized recording of the proceeding. And I do know, finally, that secrecy, or at least security, and controlling the involvement of outside parties can, if you're not careful, be quite a challenge. I'm certainly aware of one example of the difficulties which a well-respected bankruptcy judge in Delaware, I think, suffered when she was presiding over a remote hearing and ended up with a rather unwanted and discourteous interruption from somebody posting a seriously unappealing video and photos, I think. So one has to think about how you're going to manage security, and there are those kinds of hiccups that you have to be prepared to deal with. My third point, which I'll just touch on briefly, is my question of when is a remote hearing not appropriate? Now, I think it's clear that many and most corporate and commercial matters will be suitable for a remote hearing, suitably structured and organized. But there are cases when they are or might be unsuitable. I mean, obviously the decision as to whether to order a remote hearing and what arrangements need to be made is a case management decision for the relevant judge to be dealt with having regard to what we call the overriding objective and principles of fairness and justice. But there is some useful guidance in the cases and the commentary on this in England. In particular, there's a very useful presentation and paper that was presented and made, produced by the Chancellor of the High Court, Sir Geoffrey Voss, about to be the new Master of the Rolls, in a presentation he made to the Chancery Bar Association in June, which is publicly available, and a link of which, or to which I think Camilla has just posted. And Sir Geoffrey there indicated 4 factors which he thought pointed away from having a remote hearing, where you had vulnerable or technologically challenged parties or witnesses who would have real difficulty working a computer or handling digital bundles, where you had witnesses accused of serious irregularities or dishonesty, particularly where there is a concern that their evidence might be subject to interference if they weren't in the same room as the judge, committal hearings where there are serious adverse consequences, such as imprisonment, that are likely to flow after the hearing, and hearings where there's such a level of public interest that many hundreds of people would want to or may seek to participate in the call. Those are the kind of factors that one has to bear in mind. There are some quite interesting family law cases, obviously a different context, but raising the same kind of concerns about the outer limits of the appropriateness of using video link and remote technology. And there's quite an interesting statement by Sir Andrew McFarlane in a case called P.R.I.M.E, in which he declined to order a remote hearing. And he said this: the reason for having come to the very clear view that a remote hearing is inappropriate is because it seems to me impossible to contemplate a final hearing of this nature where at issue are a whole series of allegations of factitious illness being conducted remotely. The judge who undertakes such a hearing may well be able to cope with the cross-examination and assimilation of the detailed evidence from the e-bundle and from the process of witnesses appearing over Skype, but that's only part of the judicial function. The more important part is for the judge to see all the parties in the case when they're in the courtroom. And though it's possible over Skype to keep the postage stamp image of any particular attendee at the hearing live on the judge's screen at any one time, it's a very poor substitute to seeing that person fully present before the court. So you may have, judges may have to work out the cases where it's not appropriate. Certainly in my court, we have tended to avoid very lengthy hearings on very complicated matters and to adjourn those where that has been something that can be justified and appropriate. So a trial that may go on for 10 days, 14 days, 3 weeks, one tries to avoid dealing with those using the remote technology. So let me finally touch on my last point about when can and should the court order a meeting in a scheme of arrangement to be held virtually. In view of the lockdown requirements, which have limited the number of people who can meet together inside, and the requirements to maintain social distancing, it's obviously been necessary to adjust the manner in which members and creditors can meet for the purpose of voting on and approving a scheme of arrangement. Schemes of arrangement are different from US Chapter 11 votes. The general requirement is for a meeting, and usually that involves people coming together not just to file their votes, but to discuss the proposal and to have the opportunity to ask questions. But the result of the pandemic and lockdown restrictions has been the need to have remote meetings by webinar. And the court in London has had to decide whether such an arrangement is in accordance with the statutory requirement for there to be a meeting. And in a number of cases, the judges have held that, subject to satisfying certain core requirements, a meeting conducted by electronic means satisfies the statutory requirement. The reference to a meeting doesn't require everyone to attend a physical meeting in the same place. But what's important is that there can be said to be something sufficient to amount to a coming together with the ability to consult. And that can obviously be done by telephonic or video-based communications. But what the courts have, I think, sensibly done is to say that at the final hearing to sanction the scheme, the court will expect to see evidence that the meeting has actually gone off well, the technology has worked, and so that there has been an opportunity for people participating in the meeting to ask questions, to hear one another, and actually consult together effectively. And a marker has been put down that if there are problems, the court may well not be able to sanction the scheme at the end of the day. That seems to me to be a sensible approach, which I think is likely to be followed in other courts. The cases, the relevant analysis was first set out by Mr. Justice Trower in the Cattle Trust Direct case, has been followed in the Virgin case and a number of other cases. And it seems to me that sets a workable and sensible, practical solution. Thank you.
All right, thank you, Mr. Justice Segal. I can tell that we worry about a lot of the same things and also perhaps see some of the same opportunities. I want to take us now all the way back down deep into the Southern Hemisphere. Actually, I'm going to take us to tomorrow morning. And my good friend and our wonderful colleague, Justice Paul Heath. Paul, give us a bit of an Asia Pacific perspective. And please, if you would touch on the role for arbitration and mediation in this new world that we're living in and how it might be used to relieve some of the pressure on courts that you've heard about both explicitly and indirectly from Nick and from Jamie. Over to Paul. Thank you.
Okay, thanks, Judge Stong. Thank you for the introduction earlier. I've been asked to talk about two discrete but interrelated issues. The first is the way in which court hearings have been conducted in the Asia Pacific region during the pandemic. The second is the potential use of alternative dispute resolution techniques should the courts end up being overwhelmed by applications involving complex insolvency cases. Dealing with the first issue and focusing first on New Zealand, I was on the bench from 2002 until 2018. Even before 2002, probably from the mid-1990s, telephone hearings in New Zealand were quite common. So that's something with which we were familiar. Audio-visual links for Banco hearings, appeals, say in a bail case which needed to be dealt with quickly, were also commonplace while I was on the bench. And though it took a little time for the technology required to be provided to the courts because of volume, I'm told that in general terms, efficient and effective hearings were achieved during the pandemic, both in respect of witness actions and in respect of interlocutory hearings where lawyers only were in attendance. Similar experiences have taken place in the other parts of the Asia Pacific area. Hong Kong is a little different because the courts were open for a longer period and had less time actually dealing with things remotely. Singapore has dealt with things remotely, and in Australia, they too have dealt with in a similar way. In Australia, they've also experienced the issues with open justice that Justice Segal referred to. A more unusual example and international example of the audiovisual technology involved one of the Pacific Islands, Samoa. Most of the judges of the Court of Appeal of Samoa are actually based in New Zealand, and so the Court of Appeal of Samoa had to conduct hearings over a week from New Zealand, with 2 New Zealand judges, 1 sitting in Samoa. The 2 New Zealand judges sat in the chambers in which I'm involved in Auckland, and Zoom hearings were held. And after the judges departed, deliberations also took place through that platform. The hearings were completed with no difficulty at all. One of the islands I know at least has got a legislation which deems a judge sitting in another jurisdiction to be in the actual jurisdiction at the time of the hearing to avoid any problems. Moving to alternative dispute resolution, I'm discussing this on the premise that public courts and the private sector in the provision of arbitration or mediation type services provide different mechanisms to resolve disputes. Sometimes it is better to go to court. On occasion, one can only go to a court. But there are other occasions where resolution in a private forum may be more appropriate, either to settle disputes completely or at least to narrow areas of dispute for consideration by the court. And that is the context in which the following remarks are made. Dealing first with arbitration, it's fair to say that historically arbitration and insolvency have been considered as incompatible. Much of the academic literature focuses on core insolvency disputes, said to be incapable of arbitration. But there are a number of areas in which arbitration can be used to resolve particular insolvency disputes. In a special report that my colleague Anna Kirk and I published through Insol International, we discussed the issue from the perspective of arbitrability. Although arbitrability is generally assessed by reference to public policy in individual jurisdictions, some themes can be drawn together from the international jurisprudence. While accepting the need for caution in applying approaches from one jurisdiction to another, some propositions appear reasonably clear. For example, disputes between parties which involve the potential to change the legal status of a person are not arbitrable. Disputes that affect third-party rights, in which ordinarily those parties would have a right to be heard, are not arbitrable. Cases where an arbitral tribunal may be asked to review a judgment given by an insolvency court of competent jurisdiction also should be excluded from arbitration because it is inappropriate for an arbitrator to inquire into the validity of a court judgment. Different tests have also emerged. In the United States, as I understand it, there is a distinction drawn between substantive and procedural core issues, which provides a basis for determination of what bankruptcy disputes can be arbitrated. That is a point that's informed by insolvency law. Another approach is to consider whether a dispute is arbitrable by reference to the question whether it is something that an insolvency representative is entitled to settle without the sanction of a court. That too is informed by insolvency law considerations. The approach that was taken in the special report differs in the sense that it focuses on arbitrability in the context of insolvency. The question becomes, are there public policy reasons in particular jurisdictions to prevent arbitration for particular types of disputes from taking place? Whether those tests simply say the same thing in different words or truly create alternative options is a debate for another day. Mediation is a more flexible technique. There is no one way of approaching a mediation setting. In the present context, I'm talking about any type of facilitation of the resolution of disputes by one or more persons using whatever techniques may be agreed by the parties. One piece of legislation recently adopted in New Zealand from our colleagues over the ditch in Australia is the Farm Debt Mediation Act. That has recently been passed and has put considerable emphasis on the use of mediation in a financial setting. New Zealand is a country that is dependent upon agricultural exports. There are many large farms, many of which comprise some of the biggest business enterprises in the country. They will be sheep or dairy farms. They may be orchards such as kiwi fruit and vineyards involving the production of wine, one of our really good exports. Many have high capital value, but are affected by market fluctuations, particularly in a seasonal sense, but also in the present day through the pandemic. The Act requires mediation before a lender exercises powers in relation to a farm debt. The debtor puts up 3 suggested mediators from an accredited panel, and the lender is obliged to pick one of them. A session is held at which an agreement is sought. If agreement were reached, it is recorded in an enforceable document. As long as the lender has approached the negotiation in good faith, it is entitled to proceed to enforce if no agreement were reached. This type of agreement can either result in something that's immediately enforceable by the parties. It might be something where there is an agreement to move to something akin to voluntary administration, or there may even be simply agreement on the terms of a scheme of arrangement that can be put before the court for sanction. I am currently engaged in one such mediation with a large property and hundreds of millions of dollars being restructured. I'll be working closely with the lenders and the debtor to try to reach a solution with the help of financial advisors and transactional lawyers. The last possibility I want to put forward involves cross-border insolvency. There is a power for the court in UNCITRAL model law cases to appoint someone under Article 25(1)(a) who has the ability to liaise with creditors and the debtor to endeavour to formulate arrangements to go before the court for approval, or at least to narrow the points to be dealt with in argument. Given the dynamics of managing some types of cross-border insolvency disputes, they may well be better managed by a practitioner in the market than in a formal court hearing. On alternative dispute resolution, the real question is this. In dealing with cases arising out of the pandemic, do not think of alternative dispute resolution. Think of the most appropriate means by which the dispute can be resolved. A mix of techniques can also be helpful. Thank you very much for inviting me. Back to you, Elizabeth.
All right, thank you all. I remind our attendees, and particularly those in their early years of practice, that you don't often get an opportunity to put a question to a panel like this, and you can do it. So please think about that. I'm really struck by the fact that in a way we're all seeing and thinking about a lot of the same things from our wildly different perspectives and geographies and caseloads. I'm thinking about training, thinking about junior lawyers, thinking about public access and access to justice and the media and the press. I think now that we're not so much planning how to get from now to the end of the day or now to the end of the week, and that's how it felt in March. I'm mindful of the line that Jamie pointed to when the NBA season was canceled and people looking at each other the next day saying, gosh, I guess this is a thing, at least in the US. This is, of course, we knew it was a thing. But this is going to change a lot of things that we do not expect to change. A question that I have for our panel as we await questions as well from the audience is, what do you think, from everything that's changed, what's something that surprised you and what's something that you think we should hold on to as we evolve into a new set of procedures and learn that, yeah, from my own perspective, things I never thought I could do, a contested argument over the phone. I've now done many, countless. You know, witnesses cross-examined by video. What's something that surprised you? What's something you think we should hold on to? Let me start with Jamie.
I actually, I guess I'd say I'm surprised that my law firm can operate as well as it's been operating, being 99% remote. And I thought we'd figure it out, but it's gone smoother than what I would have expected. And apropos to that, I think both in terms of what goes on in court hearings and what goes on everywhere, people are going to examine what really needs to be in person. Now, I, for one, believe that a lot needs to be in person. I mentioned serendipity earlier. I'm a big fan of that, and I think the in-person allows that to happen, and a lot flows from that. But I do think there'll be an examination of efficiency. I haven't looked at the fee applications we have to file in the United States, but that we're filing on behalf of my firm. Lucky for me, other people do that these days. But the expenses, I don't know what the percents are, got to be way down with less travel, just less everything. And there's an element of that that's good for the client and good for the system. There's an element of maybe that's not a free lunch, but I think there's, and even what we do internally with having people in person in various cities and training sessions and staff traveling around, those are all things that I think will go back to normal, but in quote marks, because it won't be 100% of normal, there'll be adjustments and we'll probably get somewhat more efficient.
So thank you for the questions, and following up on the points you just made, and I've just disappeared them. Let me bring them back. I'll start with Jamie, and then anyone else who has a thought. Do you perceive that the communications you have with your colleagues are more transactional? Are they more focused on the particular business you have to get done? Is there still the opportunity to say, how was your weekend? How you feel? What do you think? Got a problem in a case I'd like to kick around with you? How can we be sure that kind of thing happens? Or is it happening? Let's start with Jamie.
I think it's early on when things were, very crazy. As I mentioned, March, April, totally transactional. There really wasn't time to breathe. Now, and I think as people have gotten a little more used to it, and a little more comfortable with the virtual stuff, there's a little bit more discussions, but I don't think it'll ever be the same as being able to sit down in person and having a meal or a drink with someone. And so we're doing the best we can, but there's a lot that gets lost in translation.
And I think about your point about the junior lawyers. I wonder how my own career path might have been different if I didn't get to sit and watch a partner handle a conference call with the SEC enforcement staff early in my career. Let's turn to the judicial perspective. Here's a question focused on that. Do you find that having the litigants not in the courtroom where they have to see each other, be in each other's physical space, not to see each other on little boxes like this, makes it harder to get a settlement, to get some kind of negotiated resolution? Is it harder or easier to encourage people to think in that direction? I've certainly got my own experience on this. I'd be curious to know what Nick's has been, and also Paul's. Nick.
I think it's a very good question from Bob. Of course, one has to think about judicial and litigation culture. What we do in London and Cayman in terms of encouraging settlement is rather different from what you, Elizabeth, and the other US bankruptcy judges do. I was always impressed, in my time in New York, just at seeing the capacity of a US bankruptcy judge in summoning people before them to encourage, through a stare, a grimace, or a suitably pointed remark, to encourage negotiations and settlement. In my court, I don't think not being in person affects what the judge can do. What I think it may do is affect the dynamics between or affecting the parties. I think the actual pressure, the immediacy, the effect of actually in-person hearings can, on occasions, affect the parties and make certain points sort of dawn into their consciousness, which might not have sort of happened if they weren't present in court. So I don't think it affects the judge's ability to encourage settlement or to make pointed comments about what issues the parties ought to be addressing. But I do wonder whether it may not affect the dynamics affecting the parties themselves.
Can I just add something to that?
I think that makes a lot of sense, and I will say that I'm working on a new skill set and set of practices to encourage exactly that kind of thing. When I can't say, I wanted to take a few minutes, step into the conference room, step into the car, or whatever it is. I want to hear from Paul, and I also want to put a couple of questions about cross-border that have come into the Q&A out there, and perhaps ask Paul to cover those as well, since this is such an enormous area of his activity and influence. Do you think that as we get more comfortable by necessity with digital communication and remote proceedings, do you think it's going to have an impact on how cross-border cases are considered, how they proceed, even how they might be thought of? Paul, what do you think?
Perhaps one comment first on what Nick was saying. One of the advantages, I think, is it lowers the temperature. It's very hard to shout into a TV screen. And so that everybody tends to have a different behavior in the way that they interact with the court or the arbitration. If I can move to the cross-border question. In the world of international arbitration, I think what is being found is that most things that people used to travel overseas to and say have 3 panel members can actually be dealt with perfectly adequately in the context of a Zoom hearing or something like that. And that's going to create efficiencies for the parties. There is generally less cross-examination in that sort of forum. And I think that the experiences of what has been happening in court and also in arbitration over the last 8 months may lead, even when we get back to something resembling normality, to more of those types of hearings taking place on an audio-visual platform. And I think the same could be said about some of the cross-border insolvency cases. I mean, where there have been joint hearings, there have already been people in physical locations but on screens to each other, which is really not much different from what you would have, except you'd have some of the participants in different places in each jurisdiction. So yes, I think there is a likelihood that the lessons from the pandemic will be used quite a lot in cross-border cases.
Do you expect any additional uptake of adoption of the model law as a result of this, focusing on cross-border cases and looking at the challenges to different economies and sectors?
I would think that it's going to certainly be focused on by different jurisdictions. I'm doing some work on some of the insolvency laws with the World Bank at the moment, and that's certainly an issue that a number of countries are looking at. Simply because the big businesses in the smaller countries are more likely now to be affected, and they're the ones that have actually got the cross-border debt. So it's suddenly becoming quite important for the smaller governments to look at this.
So we're in overtime. I'm going to ask one last question and then thank all of you and thank our audience. And here's the question. What's a piece of advice that you would give? And who would you give it to? Would you give it to CEOs? Would you give it to people in government? Consider what advice you might give to a new lawyer trying to figure out if restructuring insolvency is a place they want to make their practice home. What's the advice you'd give? I'm especially thinking about those younger lawyers, and we're lucky to have several participating today. But what's a piece of advice that you give? Would it be don't wait too long? Actually, you can give more than one if you'd like. But maybe I'll start with Paul and then work backwards.
I think it's focus, as you should anyway, on the interests of your client and work out what is the best way to deal with this problem. Recognizing now there's a bigger toolbox available because we've tried techniques that otherwise haven't been considered as useful. So look at things with a broader mind in terms of working out the best way to solve a problem. That would be my advice.
I like that advice, and that's pretty broad spectrum advice. Nick, what's a piece of advice you'd give and who would you give it to?
Well, I would say if it's to the legal community in terms of either litigation or dealing with cases, think ahead, be innovative, and don't forget the case law.
Spoken like a judge, my friend. I love that. Do you have a case for that proposition, sir or madam? I've asked that question a couple of times. Never mind controlling authority. Any case, anywhere. Jamie, you get the last word on the advice question.
Well, particularly for young people, I always tell people to be lucky. And actually what I mean by that is put yourself in a position to be lucky. And apropos to what Nick and Paul have said, the minimum bar is subject matter expertise. So you really got to be good and knowledgeable about what we do for a living. And then, but that's just the price of poker or the table stakes. After that, get out and meet people, get out and know people and do things and put yourself in a position for some luck to happen.
Show up. I'll end with a piece of advice, two pieces of advice I've shared from time to time. They come from what I like to call my two favorite Western philosophers. One, Wayne Gretzky, is you always miss the shots you don't take. This is not a time to be shy about what you want, the kind of things you think you can do to make a difference, including in keeping companies in business, keeping jobs in communities. And the other, and people who know me know what's coming, goes back to a long time ago when I was filling out a scholarship application, which was in my own personal financial restructuring as a high school student needing to pay for college. And I was concerned that this one just wasn't going to happen. It was too far afield from my strengths, math and science. It was a liberal arts award. And at that place where all wise things happen, the kitchen table, my mom, may she rest in peace, said, they have to pick someone, might as well be you. And so, we're going to get through this one way or another. I think you've got a lot of good insights about where we are, where we're headed. Phases 0 to 5, things that judges like to see, some reminders to be creative and thoughtful in solving problems. We don't need this anywhere more than in the enterprise of companies in financial distress, from the largest to the smallest. Every big company was a small company once. So I'll say thank you again. I'm going to check and make sure I've touched on all my housekeeping points. Thank you each and all of our panelists for your contributions. Thank you to our attendees for joining and for staying to the end. This is one of our primetime virtual events. We have pivoted, where we all got much more familiar with beginning about March, to these events, and I hope you enjoy them, and please do sign up for the next. You can see the details of our upcoming events in the chat. You can also find them on our webpage. P.R.I.M.E Finance in your search engine will get us there. Thank you, of course, to our sponsors. And again, thank you one and all to our fabulous speakers, and to Camilla for running the show. And thank you for letting me go till 10 minutes after the hour.
Thanks for having us.
Yes, thank you very much indeed. Thanks.
My pleasure. Thank you one and all. Reach out to a young person today. That's my assignment for you. Take care. And thank you again.
Thanks a lot.